Right. I would like to start by thanking Elra for their invitation, asking me to share with you my practical experiences of CROBECO 2 as an English notary, participating in the pilot to real estate transactions in Spain. In particular, I would like to thank Jesus Gami and Jesus Ortega for their continued support throughout the few months we've actually been dealing with this. And the whole team at Registradas España. I would also like to thank Lynn Loam for his continued close involvement, and Maria Jose Cobo for the support which she's providing through the NetPro system. And without them, it would be very difficult to continue with the program. Now, okay, much has been said about the importance of CROBECO and of the technical merits of both the pilot and of NetPro. However, in my view, we can only really assess the positive impact of the pilot by measuring it against the reaction of those it is intended to benefit, namely the citizens who are availing themselves of this service. For this reason, I wanted to concentrate my efforts in sharing with you how the clients I have seen and how they benefited from using their national law and the applicable law to their contractual and non-contractual obligations in respect of a transfer of real estate in Spain. So, what has been my experience of this? Since becoming involved in CROBECO 2, I have had the opportunity of transacting two matters in which both the seller and the buyer chose specifically to apply English law to their contractual and non-contractual obligations of a sale of a land situated in Spain. The first transaction related to a property in Malaga, and the second was in the Balearic Islands. Both of these transactions took place using the facilities provided by CROBECO, with the electronic digital filing of the conveyance instrument and payment of taxes via separate arrangement with the local gestorías or processing agents. The contractual clauses and the clauses of the conveyance used were produced with the help of the repository of standard clauses as adapted as required, which at that point were actually held in a secure SkyDrive facility. This meant that the parties to the transaction had the benefit of having the text of the conveyance in English, with the Spanish text provided for the presentment and formal registration of title at the relevant land registries. So, what were the advantages? Both parties to these transactions were in fact delighted at the efficient and secure method of the transfer of title, and in particular they were happy because they were able to formalise the contract and the transfer of title in their local currency, pound sterling, effecting the payment in England, thereby avoiding the high cost of international bank transfers and currency conversion costs in relation to the full price. They avoided the cost of the need to travel to Spain in these particular cases to sign the conveyance before a local notary. They avoided the need of executing a power of attorney in favour of a third party, which would have meant losing control of the transaction. And having had the document produced in bilingual format and its meaning explained to them, they fully understood all the implications and the terms and conditions of the contract. So, why was this choice exercised? I think to try to understand that, we need to understand a little more about the individuals involved in these transactions and the circumstances which led them to wish to apply their own national law to their contractual relationships. Now, from the seller's point of view, in both cases, in both of these transactions, the seller had been recently bereaved. In both cases, they were emotionally vulnerable people and in need to dispose of a Spanish asset following the death of a loved one. In both cases, they drew comfort from the full understanding of the transaction entered into and from the familiar environment in which the completion formalities took place. Now, from the buyer's point of view, they were able to receive the assurance of myself as a public officer that all the searches and inquiries had been conducted by me prior to the transfer taking place, and that their title would be presented immediately for registration. Direct electronic submission of the conveyance by the notary to the land registry of the receiving jurisdiction, in this case Spain, provides greater protection to the buyer. This is because with CROBECO, it is no longer necessary to wait to receive a hard copy of the conveyancing back from the Foreign and Commonwealth Office or the apostille affixed to it before it could be presented to the land registry. It's presented in electronic format. With CROBECO, priority is conferred immediately on electronic lodgement. Now, from the point of view of both parties, the choice of law in the home country providing a better understanding of their contractual obligations with regard to that particular transaction. It was possible to engage in a process of preliminary inquiries from the vendor to establish certain non-contractual obligations which might have arisen from the transfer. It provided a more flexible avenue for redress, as far as they were concerned, via local English courts in the event of any disagreement arising in respect of the contractual aspects of the transaction. Knowing this was a source of comfort for both sides involved in the transaction. So, what does NetPro add to this process? Well, NetPro provides a further facility improving the way foreign conveyancers may deal with contracts involving the transfer of land outside their own jurisdiction. NetPro does provide what we could call a one-stop shop, enabling the foreign notary, by the use of the help desk, to obtain not only title information, but also, for instance, deal with other issues such as NIE applications, deal with planning and local town hall inquiries, deal with payment of transfer taxes arising from the transfer of the title, payment of land registry fees, and supervising the registration process. The migrated repository of clauses, and I say migrated because it's moved from the SkyDrive facility to the NetPro site, means that the tools required for preparing the contract or conveyance are now held in one place. So, since beginning this, and I've been fortunate enough to be instructed on a new transaction in which both the buyer and the seller are resident in England and Wales, and have decided that they want to apply the English law to their contractual and non-contractual obligations in relation to a transfer of land in Spain. I'm therefore hoping that in the next CROBECO conference I will be in a position to provide you with a full report on the functionality of NetPro in the context of what we would call a live transaction, in other words, one where it's not a test scenario. However, this particular new transaction is in the early stages of the contractual process, so unfortunately it was not possible to test it with the current system. With the use of NetPro, I believe that a clear workflow plan will emerge, which can be contained, managed and developed, if the notary so wishes, within the NetPro portal, improving the efficiency in the process. To illustrate this, I would like to give you a quick procedural example which may explain a little further the sort of work undertaken within this context. To begin with, two parties in England and Wales will agree to transact a purchase and sale of a property in Spain. And in my experience, these parties will be resident in England and Wales, and they will wish to transact the purchase and sale because they want to do it for a variety of reasons, which I'll give you examples of later on. and they then decide that this is how they want to do the transaction. Now, at that point, the notary will interview both parties to establish their legal needs, and there has a discussion as to the applicable law in connection with the contractual and non-contractual obligations. The notary will collect the original documentation in relation to the title and review the paperwork with the parties. The notary will conduct a land registry search and any preliminary inquiries from the vendor which might arise at that particular point. Now, using the example of NetPro, the notary would agree a service level electronically with the NetPro Custodia in terms of the services which they're going to contract with the Custodia, and whether the services are contracted through NetPro or otherwise, an application would need to be made in relation to the NA required for the applicants or both parties. Then, as soon as the NetPro Custodia, they would be instructed to obtain confirmation of freedom of municipal debts and liens, and an application would be made for cadastral certification for confirmation of no obvious plot discrepancies. The notary would consult the NetPro repository and draft the conveyance or contract and adapt this as required for their case. There would be a further meeting between the buyer and the seller and the notary, where the contract would be ready for signature and execution before the notary, and the notary would have made all the necessary checks in relation to the origin of the funds which are actually being used for the purchase of the property, and evidence would be attached to that document to show how the payment was actually made following compliance with EU anti-money laundering regulations. The document would be signed and title would pass to the buyer. The notary would then, with his secure signature, submit the electronic conveyance in electronic format to the relevant land registry, and would arrange payment of the transfer fees via the NetPro Custodia, and there would be a submission of the tax payment to the land registry, so the land registry knows that all the transfer taxes have been paid. The NetPro Custodia supervising the registration process would make a payment of other taxes, such as the municipal plusvalía tax, and it would actually confirm payment of that tax to the land registry. In the case of non-resident buyer and seller of property in Spain, there would be a 3% withholding tax, which would have to be deposited to the Spanish tax authorities on account of the seller's potential capital gains tax liability in Spain on disposal of real estate. And the Custodia would deal with the supervising of any other documentation that might be required until the completion of the registration takes place. If there were any difficulties in relation to the registration of that title, those difficulties would be notified directly by the land registrar to the issuing notary of the conveyance document. And at that point, the registration would be completed, and the land registry confirms full registration of title. The documentation is returned from Spain, and we have one very happy buyer. Now, I would like to draw some conclusions from this, and I'm sorry that probably the conclusions are a bit longer than the presentation itself. But I would simply like to say that there may be many reasons for parties preferring to select their national law to regulate their contractual and non-contractual obligations when transacting a purchase of real estate in another member state. I would like to hint at some of these. by setting out a non-exhaustive list of examples. For instance, one could be when a property in Spain is sold under the terms of a voluntary auction in England, and the auctioneers in England wish to import English-style special conditions of sale, which is a quite a normal thing to do for auction properties. The next one could be, for instance, where the seller is incapacitated and is being represented by an attorney under the provisions of an English lasting power of attorney. Now, these documents are actually prepared in advance of the donor actually losing mental capacity, that they continue to be, it's possible to continue operating with the authority even though the donor has actually lost capacity. An LPA as it stands is very much a creature of English law. It is English law that will determine the form of validity and the extent of the authority conferred under such mandate, all of which an English notary would be best placed to confirm to the receiving jurisdiction that the document is actually valid. We could, for instance, see a case where there's a transfer of Spanish title between two English limited companies, and where an understanding of the local corporate structure is required to confirm authority, understanding and capacity of the representatives. We could turn to the examples that I've experienced where, the parties are emotionally vulnerable, where familiarity and understanding of what's actually going on fosters confidence and certainty, and avoids the possibility of unwitting emotional abuse of that sort of vulnerability that these people are experiencing. It could be you have a situation where mortgages, English mortgages, so a situation where a purchase and a sale is transacted with a loan from an English banking institution where they want to release funds in pounds sterling. Or there may be other practical reasons why they want to complete the transaction in the UK. There may be simple commercial reasons to save costs and time by not having to travel. So there could be a number of reasons. Equally, there could be many reasons why the transaction should and will be completed in Spain. Even though you have two non-resident English people transacting a property in Spain, as has been the case in the business. And I won't go into all the reasons, but there's as many. So in other words, there could be many reasons why parties may choose to regulate themselves and the transaction they're entering into by their home law. And I sincerely hope that CROBECO will provide the opportunity to explore in practical terms each and every one of these types of issues. And I think, in terms of my presentation, that's really all I wanted to say. And I wanted to thank you for listening and for being so patient, and invite you to ask any questions from this point on. Thank you.